for everyone to be physically present. So I'm going to hand it over to Phil Weiss, who is the founder of New York Legal Hackers and instrumental in the growth of the legal hackers movement. We've prevailed upon him to run this next session on crowdsourcing the law. You all know about crowdsourcing. Finally, law is catching up.
Thank you, Professor Askin. Thank you all for coming. Technology, we explore that issue, explore why it doesn't lend itself towards traditional regulatory methods, and then propose new solutions. Just about a month ago, we did a hackathon on data privacy. That was great. We did it in 3 venues in New York, San Francisco.
Law is catching up.
Hello? Thank you, Professor Askin. Thank you all for coming. Wow, I don't want to talk anymore now that I've heard my own voice. So we just had a data privacy legal hackathon that went very well. And our next event will actually be on... explore that issue, explore why it doesn't lend itself towards traditional regulatory methods, and then propose new solutions. I feel like someone's mocking me. A month ago, we did a hackathon on data privacy. That was great. We did it in 3 venues in New York, San Francisco. Watching the live stream. Okay, so Judge or Jake, if you have headphones, please, if you could use those, we'd appreciate it. I'm not talking to fake people. They're actually here with us. So next event is going to be on the music synchronization right as it pertains to online video content and how publishers have recently used this right to take down content for even non-commercial videos that exist on YouTube. And we're going to talk about that and possible solutions to that problem. So let's get to our panel. We're going to be talking about crowdsourcing the law. Now, crowdsourcing obviously has been extremely important to our internet economy over the last decade or so. And I think we've learned a lot from the crowd. The success of companies like Wikipedia and Quora and other massive crowdsourced platforms show you just how good the information can be coming from the crowd, and thus the term the wisdom of the crowd, if you will. Not necessarily reliable information, but information nonetheless, and a lot of it. We'd like to take this concept and bring it to certain ventures that exist in the law and legal services. So with us today, we have the Honorable Amedeo Santosuosso, who's a judge for the Court of Appeals from Milan. We have Matt Hall and John Watkinson, co-founders of Docracy, and Jake Heller, who's founder and CEO of CaseText. So I don't want to say too much. We're a little bit behind schedule anyway, and I think a good place to start here is, what is crowdsourcing really? What is crowdsourcing the law? And just by way of intro, just introduce yourselves and let us know how you're interacting with this concept and what you think of it, just as a general impression. So let's start across the pond with Judge Santosuosso. Judge, yes. Are you there?
Yes, sir. I am here. Good morning. My presentation, even though it is connected in a very particular way. So the focus of my presentation is legal multilingualism. That is a problem that is very important. more updated. But in any case, at least till now, I think that it is still necessary some basic human work connecting legal concepts. So, just a few words about what is this archive. ELST stands for Multilanguage Archive on the Law of Science and New Technologies. It is a project of the European Center for Law, Science and New Technology at the University of Pavia. ALST brings together cases and materials, and each of them is considered as a piece of law and is linked to similar pieces, whatever the country it comes from, whatever the language. Every material is written in its original language, but it has a file card that is drafted in English and that allows the communication among many different documents and languages. And so each piece of law can be retrieved through keywords entered in English and or national languages. So the practical facets of the archive are very simple. ALST offers the people the opportunity to know the existence of cases that they do not suspect. For instance, I work in Italy, and it's possible that a similar case exists in Japan or in China, or I am not able, in any case, to know even the existence of this case. And so through this project of archive, I can get the basic information on the case, and this basic information is given in English, and I can have access to the material, to the original material in its own language. So once a user starts a query, he can use whatever language. And whatever the user language, the system establishes connections in all languages that are used in the archive. So the connection between legal concepts is possible thanks to a multilingual thesaurus that is provided and implemented by a company that is called Pool Party, and we are working with these people very well till now. So, very shortly, the theoretical background. In the lower part of this slide, you can see some references, but the main concept is that law nowadays is fragmented in space and time, is not hierarchically organized, at least in a stable way. It is not necessarily directional in the sense that spontaneous developments are every day more important than the intention of the lawmakers and so on. In the general legal scenario worldwide, there are a lot of different actors in this very technologized global environment. And so, according to the philosophy of the archive ALST, legal international and transnational experience looks like an immense web, ever-changing and connected. So this is the last slide. Of course, we have some critical aspects. ALST is still a prototype, and it is not accessible yet on the web, because we have decided to open it once we have reached a critical mass of information in order to have the, let's say, regular functioning of the archive. On the other side, the archive, this project of archive, implies the existence of international cooperative groups of people that work in a networked way. Just to make an example, we have materials and cases on neuroscience and law because we as group in Pavia, at the University of Pavia, are very active and we have a position of leadership in the international landscape of neuroscience and law. So there is a group of people already working in this area, and then we can propose them to share this tool. And other fields are the fields of robotics and law, privacy, and others. But of course, this is very expensive, because when you have to have people that have to work in this area, it takes time and funds are necessary. The alternative is a wiki development. But I have to be sincere, I am a little bit reluctant, because I am afraid that the level of accuracy of the translation from national languages into English as pivotal language perhaps wouldn't be so good. So I hope in a reasonable time to have the possibility to show you the archive, even though in a still embryonic form. Thank you. Thank you very much.
Thank you very much, Judge. Now, Jake, before you go, we are going to have to disconnect the call so that we can share the screen. So we're going to hang up on you. I'm sorry.
Okay.
And then we'll call you right back, okay?
Sounds good.
In the meantime, I think the judge raises an important point here, and maybe a major obstacle to crowdsourcing the law. So the beauty of crowdsourcing information in general is that you just get a ton of it. The thing about the law is that it's very important, and that language is very important. So I know that some have discussed, I know I've at least thought about the possibility of crowdsourcing law in a very real sense, right? We're all collectively drafting legislation. That becomes a problem when language is such a huge factor here. And I'd like to put a pin in that issue, perhaps, because one issue that we're seeing here in the States when trying to parse out statutory text, for instance, is that there's no standard form for publishing statutory text online. Many have resorted to XML, for instance, as a good markup language, standard markup language for that text. But that's not uniform, and no state is required to release their statutory text in that form. So we see issues in that sort of collective standard issue. Jake, do we have you back now?
I believe we do. You guys hear me?
Great, yeah. So please, Jake, please introduce yourself and let us know what you're working on.
Sounds good. Hey, Brooklyn, can y'all hear me?
Yep.
Awesome. Okay, so I'm Jake Keller. I'm the founder and CEO of a company called CaseText. And I think I'd like to start by touching on the questions that Phil raised. What is crowdsourcing? How does it apply to the law? And I think that a little bit of background and context really helps here. So before the internet, if any of you can remember that, we all used to get our information in one way. It was through books. We would essentially get information disseminated by experts to people who would buy it. And the result of that kind of process of disseminating information in a one-way conversation was kind of twofold. The first is that it was expensive, right? Okay, so I'm Jake Keller. I'm the founder and CEO of a company called CaseText. And sorry, it just kind of broken with a bit of audio. Is that are we coming through clear?
Yeah. Yes.
Okay, awesome. So the kind of results are twofold. The first result is that it was expensive, right? It was controlled by the few people from whom you must purchase the information, right? So we have Encarta and Britannica. And back in the day, I still have actually shelves and shelves of CD-ROMs before the books of encyclopedias. And the second problem is that it was based on a small cabal of self-appointed experts, or not even self-appointed, sometimes they're widely recognized as experts, and there's no diversity in the opinions that were being shared. Organically, what we saw is the old model was displaced organically by the web. Web technology appeared, and these things just popped up out of nowhere without almost any thought. They just happened. So Encarta and Britannica were displaced by Wikipedia in the very early ages of the web. Software, which was written by the experts at IBM and Microsoft, for example, was there's still kind of an ongoing process here, but it went from a kind of one way, we write with the software, you use it, to open source software that people collectively put together, to entire operating systems like Linux being written by a group of people, code being shared on sites like GitHub. And kind of a more social aspect of it, I don't go to a restaurant today without checking Yelp. I know, nobody goes to Zagat anymore. Maybe they do, maybe, through Google. But, I don't go, and I live in California. Traffic is a big issue for us. I don't drive now without checking Waze. And nobody uses the teleatlas traffic information. Probably you guys have never heard of teleatlas before. And it's that these crowds have done so much better than this information coming one unidirectionally from the experts. The benefits of this approach so far have been that it's free. You have free open source software, a free Wikipedia, and even more interesting, in my opinion, is that the quality of the information has over time evolved to be better. So Wikipedia they've actually done studies on this. They've proved scientifically, on scientific articles, they proved that the Wikipedia articles were on the whole more accurate than what you get in encyclopedias like Encarta and Britannica. And I mean, just from personal experience, the aggregate star rating of a Yelp restaurant far better predicts my, likelihood of liking a restaurant than what a single person or even a group of people at a company like Zagat says. So that's what that's the kind of world I grew up in. I grew up in Silicon Valley. I saw this happening, and I was excited by it. And then I went into law. And the first thing you do when you get to law school, one of the first thing I did was you get quickly introduced to legal research platforms, which to a lot of people, I think, are a vast improvement. They're a vast improvement on reading it in books, in the sense that you can now search through it, sort your search results, save your own personal notes, and so on. But in a very real sense, it's not very different than what legal research was like. Getting information through legal research was like through books. You get information from a single group of experts who write the head notes, the case summaries, who do shepherds, and it's just like what it was when it was through books. It's very expensive. It's a one-way conversation that you pay a lot of money for, and in that respect, legal research has for a very long time reminded me of of pre-web technologies. And so I'd like to share with you, what I've started in order to kind of counterbalance that. And I'm curious, can you guys see my screen? Yes. All right, so this is case text. This is the thing I've been working on for the last 9 or so months.
Wait, we cannot see your screen, sorry.
Oh, you cannot see it, okay. Well, that's different. What about now?
Yes. Got it.
Awesome, great. All right, so this is case text, available at casetext.com. The whole idea behind case text is we can build something for free that is a step ahead in legal research, that as a community of people working together, we can build something more interesting than what you can get for paying literally millions of dollars. And that's the basic premise, right? And kind of like as the homepage says, legal research on the shoulders of giants. The idea is why not do legal research if you can have it benefited by the annotations, thoughts, and notes of some of the leading experts in the field. And I'll get into it and probably during the question and answer what the incentives are for people to participate, which is always a big question in any crowdsourcing experiment. But just quickly to show you the kind of things that have already happened. We've been building the product, to be perfectly honest, and just replicating LexisNexis technology is never easy. So the community is just getting off the ground, but I think that there's some pretty exciting early results, especially on some of the biggest cases, like Ashcroft v. Iqbal. For all you law students who haven't come across it in civil procedure yet, you will come across it. And one of the things that's really cool, so we have certain things like a quick fact section at the top that includes a holding and a summary. All this is written by the community. You can expand it out and read, kind of a big picture background of the case. before you jump into the text itself. But one of the things I think is really cool is we have a person named, it's Professor Alex Reinhardt. He's kind of down the road. He's in Cardozo University. And what I think is really cool about this annotation in particular is this is the guy who argued the case on behalf of Iqbal. And he's also a professor. And the combination of the two means he's been studying this case. I mean, he lost. So he's been studying this case very intensely since the time he's argued it, even from before when he argued it. He's a lot of commentary on it. And, as you guys may recognize from sites like Quora or Reddit, there's an upvoting and downvoting system to sort the best stuff to the top. This is by far the most upvoted thing on the website right now, in part because you have an expert who is thought intensely about this issue and is pinpointed the paragraph in the case that has to do with that explains how judges have been confused going forward ever since Iqbal and Twombly. Other small cool things. In other big cases, we are kind of lucky to have we have a working relationship with a lot of the biggest firms, and they have they publish so much information about cases as they come out. They have this intense need and desire for people to read their stuff because what they want more than anything else is for them to be viewed as the leader in X or Y field, like an IP. And so they've kind of happily integrated a lot of their content into case text. And what's cool about this is when you're doing research on case text that firms have written about in the recent past, and we're still integrating all of this content, you can read an entire case summary and analysis right there at the top of the case. And again, this is all 100% for free for us and for the world. And what I think is cool about it is this section over here. I don't know if you guys can read it on the screen. I can only imagine it's kind of small, but you have this thing. It says implications, right? And that just doesn't happen when you pay millions of dollars for a case summary. They just kind of rotely describe the posture and the holding, but the incentives here are aligned in such a way that the authors of these articles want to actually take you a step further. They're trying to prove to potential clients and potential people they may want to hire that they're on top of their stuff. Two quick final examples. The one is that this actually helps quite a lot during search. So we have worked with a number of directors of law libraries, and the law librarians and legal research experts have been very involved in this project from the beginning, which is fun and awesome. One of the proposals we got was from this professor named Richard Leiter, currently at the University of Nebraska. And he said, there are only some cases that have been studied very intensely in secondary literature. Why not make a filter that you can narrow your search to only those cases that have been cited extensively in secondary literature. We call this the leading cases filter. So you can add tags to any case you want to make your own search filters, and people have been doing this. You can see them kind of running along the right side. It's a little ugly right now, but we'll fix that. But one example of the leading cases filter in action is you search for a word like patent, and you get 46,616 cases back. And you're like, well, maybe I only want to see U.S. Supreme Court cases about patents. It's still 3,500 cases, which is way too many. And that's the kind of the typical research experience you have when you're doing research on some of the bigger products. What's neat is you can click the leading cases filter, and now of the 3,500, the 400 that have been discussed extensively in the Supreme Court that are leading cases kind of pop up immediately. And then you say, well, I want to only see the things that I or somebody else has tagged innovation. And now we're down to the two cases that deal with patents, innovation, and leading cases. And I think that's a kind of a neat way that collective tagging can make the search experience much better. Final thing we'll cover is something that actually happened at Brooklyn Law School, believe it or not. One of the things we've been doing is a project called the Weiss site. And this is our most recent big push is to get a kind of a form of shepherds that is done instead of by individual, quote unquote experts at Lexis or Westlaw. We have a community of people contributing, moderated, of course, by a cadre of legal, the law library community has been extremely involved. But the initial effort has been done in people's homes and in classrooms across the country. And this is a case that was cited by a group of Brooklyn law students. You might even recognize some of these names. What's cool about this is instead of just having a flag, what you get to have instead are the actual typed out descriptions of how two cases relate to each other. Because that's what you get with the power of the crowd. People can describe the relationship between two cases. And they mark it as either distinguished positively or negatively affecting a case. You say, I want to see distinguishing treatment. And then it's sorted by votes, again, to signify what should be read first. And so, this one has been, by 23 people who have come across this case, Granholm v. Field, has voted this as the most important distinguishing case you could be reading. You can also, of course, do newest to oldest, or, only positive. Point being that you can kind of get really in depth into the relationship between cases. And again, because it's all being done by a community, this is all for free. And so I think this is I'm very excited. We're working in this field. There's a lot more we can even be doing to add to this. But what we're trying to do is the very budding beginning of a movement to make the law and the understanding of law free.
Great, thank you so much, Jake. And so last and certainly not least, we have John Watkinson and Matt Hall from Docracy. We've gotten perspectives on crowdsourced legal citation and crowdsourced legal principles across nationalities. Finally, I think these guys represent crowdsourced, I guess, consumer law, because we're talking about contracts, right? We're talking about crowdsourced contracts, and for all intents and purposes becomes law. And they wanted to show you a little bit of Docracy, and I'll let them take it away.
Hi, thank you. As Phil said, we represent sort of the other end of the spectrum. If these are sort of crowds in the expert sense, we're sort of mob rule. People, anybody can participate in our site, and that's sort of the point in some sense. So we're just going to give you just sort of a look at what the site is, just briefly, so you can understand sort of our... I keep talking. I'm going to stretch it out. Take a little time here. And when we started, it was sort of the idea was that there's no place for this. Basically, Docracy is a repository of contracts, and they can come from anyone. They can come from a lawyer, from a person from like an idiot. Anyone can upload these things. So the idea originally was met with a fair amount of skepticism. These are not the kind of thing that you should be uploading and then going and downloading just with no real idea of what you're doing. But what was sort of touched on in the Shake Law presentation is there's this vast bulk of low sort of low danger transactions that go on out there, where kind of understanding your counterparty is most of the benefit of doing those contracts. So. And people were not potentially not even getting that from legal help, even if they were willing to pay for it. That what they wanted was just to be able, both parties, to understand what they were agreeing to. So that was our idea and what we wanted to do was sort of test that the feasibility of that as quickly as possible. So one, would anyone contribute a legal document? What kind of person would do that? And two, would anyone trust it enough to download it? So we'll give you just an idea. We're a fair ways into this now. We're a few years into it. So the contracts on our site are kind of all over Google now. Search engine optimization is a pretty long game, but we're getting there. So we'll start by giving you a search. So an independent contractor agreement is one of the more popular contracts on our site, and kind of hits the meat of what people use the site for. So if you search for it, we're the first result for that now. And this is a contract that, if we click on it, has been contributed by a lawyer. And you'll see this is basically what the point of the site is to provide, first of all, the full text of the document, so there's no kind of sneaky stuff. We're not a document builder in that sense. You don't piece things together. We give you the whole thing. It represents a coherent viewpoint, like a person who does this, here's what I recommend, stuff like that. So what we focus on is basically letting you customize it in those few ways that you'd want to: values, dates, names, things like that. And what we do is we simply track the usage of this document. We track who it's from and how it's used, and then let you decide beyond that. So this one is from a lawyer, and you can see on the right side we track a whole bunch of stuff. Stats about the lawyer. We track views of the documents. This document's been viewed 237,000 times. It's been downloaded almost 1,500 times. It's been saved by somebody 250, and it's been signed 106 times. So, then signing is sort of the second phase of this, which I'll just touch on. We won't give you a full look at that. So the interesting thing about the platform, one is you can contribute these documents and get them. So that's, from a consumer point of view, that's what they're looking for. But sort of the trick that we've done here is that we can allow you to edit these documents on the site, customize them for your needs, and contribute it back to the community, and we track sort of the heritage of that document. So if you look down here in related documents, you can see a few things that are basically based on this document and have been changed by somebody else. And you don't really know until you click through what the details are there, but we'll pick one here. And this is for, basically it looks like it's been modified for development, so like software purposes. And since we know what the original document was, we can show you the changes. We can generate a red line, basically. So we use so we're both basically developers. So this is natural for us to take a look at what changed in software, and we thought it made sense to do here. So we've done a version of that for this.
Wait, you're not lawyers?
We're not lawyers. We've been to a bunch of these conferences, so we're pretty much lawyers, like you guys. Are we getting an honorary degree? Does that happen at this? We speak at graduation. So we'll probably speak at graduation. I accept your invitation. Thank you so much. And we'll get a quick honorary degree. And then we'll be lawyers. So, but right now, not lawyers. That's true. We don't know anything about this. For us, this is sort of like a black box. Like, there's data and there's information, and we'll track information about it, but you're the consumer of this. You decide, and people who produce it, like, is that person someone trustworthy, and so on. So here's the red line. Here's of that document. And over time, what's happening is that these sort of, canonical basic documents, things like an independent contractor agreement, are getting customized for this long tail of uses and being contributed back. So you can find something that's very close to what you're trying to do exactly, rather than having it be customized. So the document corpus is sort of growing over time and becoming more and more specific. So, and the second phase of what we've done with this is we've taken this and we've added signing. So you can do the full transaction within the confines of this system. So you know where the document came from, and you know who you're signing it with, and you know how you have changed it versus this original document. So the idea is that you can make this transaction so much simpler for someone you don't know that well. Let's just use the thing that everybody uses on Docracy, and I know you haven't messed with it because I can see that you haven't made any changes. So that's sort of the full picture as the site stands now. I think that's sort of it.
Just this handsome gentleman here is our mascot. That's Eric.
Oh, Eric, put up your hand over there. Look at how this is our homepage from our site, and Eric's been there for I think a year now, and look at how hard he's working. See, he could work like that hard for you. So that's a bunch of we make lawyers look great on the site. So if you have documents, you should put them up. We have these pretty cool profiles for lawyers. That's it.
Great. Thank you, guys. So we only have about 20 minutes left, but I think there are a few questions I'd like to pose to all of our panelists, and then maybe open it up for a few questions from the audience. But I think the first question is, we've heard about legal citation, we've heard about crowdsourcing, the drafting of legal documents like contracts, we've heard about crowdsourcing legal principles across nationalities. What are some other areas of law or legal practice that, based on your experience, really lend themselves to this kind of crowdsourced model in any fashion? And I throw that out to anyone who's willing to take that. Perhaps Jake?
Sure, yeah, happy to. This is a little more out there, but some people have talked about crowdsourcing laws themselves, or at least the drafts of laws. One of the challenges you have pre-technology is when you're trying to propose a bill to Congress, even for interest groups, you'd have to hire a representative or a lobbyist, be it as it may, to write the bill that you're going to propose to Congress that you want them to pass on your behalf. And it never fully captured the full views of the community that this representative was representing. And I think that there are kind of interesting opportunities. If the system's set up right, you can't probably just can't have Wikipedia rules like editing and unediting everything. But you could maybe have a situation where the views of the community were taken very deeply in the drafting of laws themselves. And I think Docracy is actually a big step in that direction. As you mentioned, Phil, as you introducing them, private law becomes the law, so to speak, as binds those two parties. And it's not that big of a step to even a bigger, push towards having the laws themselves being, at least the initial drafting of it being crowdsourced in some fashion. I think that'd be kind of cool.
I mean, obviously, you guys, well, you described it at one point as GitHub for legal documents, right? So
that's right.
So Matt, John, what do you think about? Have you taken a look at the crowdsourcing statutory text efforts and legal documents efforts on GitHub? What do you think of those? How do they differ from your efforts? Where can we go next?
Yeah, I mean, obviously we've focused more on sort of consumer law, and the things that we find really popular are sort of, freelancer, and a lot of individual law, even stuff that's sort of almost like form letter, like barely even legal, like things like a 30-day move-out notice or, a friendly collection letter, like that stuff's popular. But when we thought about where could it go, and obviously, you could be drafting entire, legislation on there or something like that. I mean, we've shied away from that just because we needed focus, and we had a big job ahead of us just with what we were doing. But some of that's happened, and because GitHub is sort of like the mascot of open source, a lot of it's happened there. We think that our diffing is much sort of more English friendly. Like if you're trying to read English text or legal text, we have a lot of smart diffing for that. Whereas GitHub is more programmer line based diffing. So we're always a little sometimes there was in the wake of, say, like Instagram's privacy policy change, and people got mad about it. There was some of that stuff was like, Tumblr or whatever, we posted ours to GitHub so you can see every change we're making, and we were sort of like, come on, man, that's Docracy. Because we do such nice diffing of that kind of stuff. So you can really, look, they changed that, that word, or they changed, that phrase to that phrase. And GitHub's not quite as convenient for that. But obviously, you get the same result. Everyone can see exactly what changed, and there's no reason why that stuff shouldn't happen.
Sure. And just to get the other side of the story here, Judge, perhaps you'd like to talk about this. I mean, what do you guys see as the biggest hurdles to crowdsourcing legal services? I mean, this is typically a pretty buttoned up private service, it's between two people for the most part, and a lot of lawyers don't like to divulge their secret sauce at all. What are some of the hurdles to putting legal advice, law out there for the public to read, comment on, state their opinion on? What are the obstacles here? Judge, perhaps you'd like to talk about this from the language perspective you were talking about earlier.
I'm not sure you still have it.
Okay, so Jake, Matt?
I'd be happy to touch on that.
Yeah, sure.
I mean, starting a community-based website is always going to be a challenge at the very beginning, because a lot of people are like, why? Why would I participate? And it's more true than ever with lawyers. What you see happen is lawyers are really, really good these days at publishing some bits of information very extensively. And that bit of information is, here's a summary of a case that just happened. Here's, these come, I should say, most in the form of client alerts and blogs, right? So lawyers, professors extensively write blogs and client alerts and client memos, and they're happy to have that read by literally everyone. I think the history behind this, for what it's worth, is kind of interesting. Martin Lipton in the late 70s published an article divulging exactly how he'd approached something called the poison pill. And people, I think, at the time were like, you're crazy. How could you be divulging this amazing strategy to protect your clients and not others? And his response was, I'm going to get all the business. I'm going to prove to the world that I am, I'm the guy you should be talking to if you want to think about these kind of issues, because I've literally written the book. And so that kind of information, in a crass sense, basically for marketing, right? You get a lot of that. What you're never going to see online, hopefully, is people dealing with what should be a one-on-one client issue in a crowdsourced fashion. I think that's actually dangerous. There are ethical rules here. You don't want to divulge client secrets to the entire world because you're collaborating on an open platform. So there are things that make sense to crowdsource and things that just kind of don't. There are places where the incentives align, and places that, I checked out Docracy, for example. There are pages when you are a lawyer or a law firm that show the contracts you work on. I think that's exactly why a lot of lawyers are contributing, because they get to show to the world, you guys can correct me if I'm wrong about this, we could show to the world, like, look at me, I am really awesome at this area of contract law. If you want the real deal, you got to hire us, but we're going to give you this bit to prove to you how good we are at drafting, negotiating, coming up with contractual language.
Does that ring true with you guys? Do you think the marketing prospects of your platform create a good incentive to create good content?
Yeah, I think so. I mean, that sort of was our pitch to lawyers, is that this is a way to get your name out there as an expert in a certain area. Obviously, don't give away the whole farm. Is that a saying? It's not really a saying.
Could be.
It is now.
Yeah.
So, and but the sort of the initial stuff, the stuff that you would probably do for low amounts of money, that might be worth it in the sense that, like, this sort of machine for people finding contracts, pointing to contracts, is exactly what Google's looking for. They're looking for the world of links to point them to the best content, and that seems to be happening on the site. So it's a worthwhile trade-off, I think. And I think that for us, like, some of the risks and stuff are on this continuum where there's things that are fine to do with this, right? There's like some, like what John mentioned, 30-day, move-out notice, things like that. Like, a contract for $500 to do a website, fine. But as you start moving up sort of the risk levels and continuum, then that's when you want to get in touch with the person who might have drafted the contract you've been using for the cheap stuff and say, like, actually it's starting to get serious. Like, I think we're pretty upfront about that this isn't for everything, but it is for this whole like sort of bulk of, like, really, like, not super interesting work to lawyers, but is sort of like this, a bulk of this kind of low-end transaction stuff.
And we had a law firm that specializes in sort of startup technology company work, and they said they wanted all their sort of initial set of documents that they would normally give their clients, they wanted those out there, because if they'd kind of take a loss on that work anyway. That really early work they do for a startup, that's just sort of like placing a bet that eventually they'll get some really lucrative work from them as they succeed. So they would rather them come in the door a little later, maybe, having not engaged them yet, but having used all their documents, so then they don't have this nasty cleanup process to get things started. And then, yeah, it helps market them as well and make them look good to the community. So we have had that kind of stuff happening.
Have you ever come across the situation where you've got a non-lawyer who's beating out one of your giant law firms on your site for their documents, and how do they respond to that?
Yeah, we have a sort of a funny example of that, which is one, and a good example. The funny example is that one of John's contracts, which was just like something we uploaded from our company when we started the site, just because it was so early that it just kind of ended up getting used by a bunch of stuff, and then when, like, lawyers we knew looked at it, they're like, that thing's not that good, you know that, right? And we're like, yeah, we kind of know it now, but you should, like, write on there, like, this is part of the thing too, is like, say on the contract it's not that good. That's fine with us, like, but
yeah, there's like a discussion section.
Yeah. So then it was like, people started pointing to some of the better stuff. It was an NDA. So now that thing's finally dropped off. So the process is working a little bit. Like, there's a bunch of this happening off-site too, which is the good example that in the design community, like sort of on like web designers and sort of creative professional people, they have some sort of, I would say, like sort of community leader type people who post stuff on their blog, like, here's how I run my business and stuff like that. And they started posting their contracts to the site. And the contracts are fairly different than the kind of boilerplate you would get from a lawyer. And they're missing a bunch of stuff. And they were saying that, basically, I didn't understand it, my clients didn't understand it, and it led to this long back and forth, and it was expensive for both of us, and it was kind of unpleasant. So I've been using this contract for 10 years, it's missing this stuff, some of it's a little risky, but it's worth it for me for this relationship, since there was a discussion of that. So that's a pretty popular document because, and some lawyers don't like it, but it's been brought in by a big community, it's pointed to by them, so it's ended up being pretty popular.
All right, with that, I think we can open it up for a few questions. We got about 5 minutes left. So if anyone has questions for our panelists.
Is anyone as scared as I was 4 years ago when I heard about Docracy, and 2 years ago when I heard about Shake Law, and this year when I heard about case text? I think, these guys are good salesmen. They tried to make us part of their process, bring us in. But is there a problem that this is the first domino in the destruction of legal services?
I think there's that fear of this is going to lead to self-lawyering, and that which might hurt lawyers' business as well as hurt these clients. But I think you have to give people more credit, than that. Like the sense we get from our users and everything is that they sort of know when they're in too deep, and they know when they need help, and so this is, there was already this sort of Sheikh was Vinay was referring, that there's already this self-learning going on at the low level, and you can't really change that. I think it makes sense to sort of embrace that, know it's happening, allow it to happen, and then do what you're best at as lawyers, which is the important stuff, and that's not going anywhere. I mean, the mechanization of law, that's a hard process. This is like subtle text that needs to be interpreted when it gets serious. So.
Yeah, two quick thoughts. Similarly, first, a lot of people, I think, when Excel came out, people were like, accountants are done. What are they going to do all day? They can't bill for any more hours because they're not going to spend all that time with the paper adding up columns. And what ended up happening instead is they ended up doing much more complicated, and I guess in the case of Enron, like kind of terrible things. But most of it was just a transfer to kind of high impact, high intelligence work, and move in that direction. I guess the second thing I would say is these on our website. And I think this is true of Docracy. And I should mention also Moodus, another really awesome, like Moodus.com, really awesome kind of crowdsourced legal research site. It's all about empowering a lawyer. I mean, for me, that feeling of researching alone, I'd show up at a Westlaw page and be like, I know thousands of people looked at this, thought about this, and I'm no better for that, for that collective effort. But I think it empowers the lawyers that are doing research, and does not disempower them. They get to see what professors, law firms, et cetera, think about the stuff that you're working on. Hopefully elevates the profession instead of destroys it. That's the hope anyways.
So the way I like to look at it is you sort of have disrupted and disintermediated the work that was essentially largely done by paralegals, secretaries, and first, sometimes second-year associates. It's the grunt work that you didn't want to do. It's the stuff that the internet could do for you now, and it frees up the lawyers to use their bona fide training that they got in law school to do that subtle, nuanced analysis that the internet can't do. For me, this is verification that law as a profession will survive without the nonsense of the early work. We'll be brought in after the fact, I think, to do what we were trained to do, and what justifies a $500 an hour salary.
Yeah.
Thanks. Hi, guys. I think it's a great product, actually. I think all of these products that help people who otherwise wouldn't get contracts and would sort of wing it or not go see attorneys, I think that's just a step in the right direction. But I've been hearing things across the morning, and some of them I agree with for the most part, but some of them it's not that I don't agree with, but I think they're sort of mischaracterized. And I think the main one is sort of the thinking that we're giving away our quote-unquote secret sauce. The reality is that lawyers are sort of hired guns. You have to go in and you have to fight for a position. And there's some contracts that when we put on websites with our name, we attach ourselves to things that may hurt our clients down the line. For example, if you go and you're acting for a purchaser and you put up a purchase agreement, as a purchaser, you can understand that you're going to be fighting for things like indemnifications that are like 50%. But you're going to have to turn around the next week and fight for a vendor, or you're going to be asking for something that's like really a fraction of that. And opposing counsel for the next 5 years is going to be pointing at something with your picture next to it that says the opposite. So I think for certain things, it's not even a question of not wanting to divulge your secrets, but I think there's certain types of contracts that just don't lend themselves well to that. And I think one of the second and last point, I know other people will have things to say, but I like the idea, even if contracts are small, I think we sometimes tend to attach smallness to monetary value, to the thinking that, oh, this is just $500, it doesn't matter. But the reality is that sometimes that $500 can be $500 of somebody, paying for something, let's say like viral open source software that they go on to build something huge for that they then can't commercialize. So, it can have implications down the line. And one of the things that I do really like is, for example, a source like, I'm throwing it out there, but like Practical Law, which I know is not very hip, it's a Thomas Reuter product. But the thinking of having some kind of checklist for products that people can sort of rely on to decide if a product is for them or not is, I think for me, it's always sort of worked really well. Not for little things, but maybe for some of the bigger contracts, broader implications like software license agreements.
So, Matt and John, do you know if anyone is using multiple presences, multiple personalities on Docracy to present two conflicting points of view so that they can be the hired gun for multiple sides?
I don't know. We don't know specifically if they're doing that or not, but it sounds like a great strategy now. Like, oh, here's a standard purchasing agreement, and it stinks.
We'll check our IP address logs. Yeah.
Yeah.
I think you're right about that, and I think we source from different members of the community, so that might be something where that actually comes from. Maybe a general counsel who does, who only represents one side of that ever, or something like that. On the topic of the so-called small stuff, where it's like that it might not be small, it might turn big. I think I guess our argument there is that no matter what, it's literally not in the budget of that project to get a lawyer. So yeah, maybe there's other tools, but there has to be something inexpensive there, because it's just not in the budget. Even if and if you believe it's going to be huge, maybe you're willing to go out on a limb. But for tons of this stuff, it's just not even a possibility to engage a lawyer for small stuff like that. So there has to be something, and obviously before these existed, the answer was most people and a lot of people who use Docracy said that prior to this they just didn't have a contract. Just, all right, I'll do it for you. How much? Good, handshake. So that's where they were coming from.
We had a question back here.
It's more of a thought. I haven't quite developed it, but you mentioned how we're sort of getting rid of the paralegal work and the stuff that young associates do and get into the real meat of it, but I think there's a value in the training of doing that stuff as a young lawyer. And I think my concern is that the technology for practice and for crowdsourcing is not is accelerating much faster than a legal education, because I know as someone who graduated from law school recently, there's really no practical training that you get except in clinics to be a lawyer. It's all case law and things like that, and things like case text are great as a resource, but there's it's a little too easy to go on and find someone else's NDA, someone else's independent contractor agreement, and not really work out what it is you're working on as a lawyer. I think there's like I said, I don't know what a question is, but I'm wondering what concerns you have as people who are developing these tools to make sort of people aren't sort of breezing by with these documents.
I guess the question is that work more like Excel, in that it's stuff that Excel replaced, in that it's replacing the kind of work that nobody really wants to do anymore, and nobody does do anymore. I don't know, but I'm assuming in accounting school, you don't start by taking out like the piece of paper and start adding up the columns yourself, right? Or is it kind of integral to training? And actually, I don't know the answer to that. I think in the context of litigation, I'm an ex-litigator, and that's the context that I bring to it. I agree with you that the real training you get through the clinics and then in real life, but starting from an elevated position, from where you get to see what a diversity of viewpoints says about a particular case or a set of cases, what the leading firms in the industry think the implications are. I think that could be your jumping off point for your analysis, and starts you, kind of pushes the starting line forward, and helps you develop your own thoughts as you see what the people who have been practicing the area for some cases decades, think themselves. So I think it's upside. But there's a serious question, I think, and you're right, is how much of the fundamentals should you have to do to really learn? And it's a question for law schools, right? Should law school, in a world where crowdsourcing and the wiki kind of approach, displaces a lot of information, a lot of the grunt work, should law schools teach the fundamentals, and get people to understand the true basics before they go out in the world where a lot of that's already been done for them? I think it's a good question.
Yeah, to me, it sounds like the legal profession's corollary to the article a few months ago is Google making us stupid. Yeah. And I don't think Google is making us stupid. I think Google is giving us the tools to actually apply the knowledge that we don't need to have, but apply it with wisdom. And I mean, I look at this like the internet is very good at one thing, separating black and white, ones and zeros, but has no ability to work in the subtle nuances, and that's where your legal training comes in. So if you can get a jump start, I wasted 2 years at a law firm doing nothing but things like discovery and document production, and these were not the legal skills. I could have accelerated. You're right, there is some value in spending a little bit of time getting some affinity with the documents, but spending 2 years mired in discovery or mired in document production, I don't think is time well served for a burgeoning, sophisticated attorney.
If I can make one final point, I think these ventures are extremely inspiring from a practical perspective. I work at a 3-man firm in Soho. We work mostly with digital contracts, and I'm active on Docracy. I use Docracy all the time to find samples of contracts that I know nothing about, just a starting point, which is a common practice in law. And I think it's also inspiring that these ventures are made by 1, 2, 3-man teams. When I'm on a 3-man team, and I can maybe bring on one more person who could make these tools for us in-house and provide those to our clients directly, perhaps. And I think that's going to be a model for these bootstrapped firms going forward, and something we're going to see a lot more of. So that's my final note. I think that's it. Thank you, everyone.
I'm sorry, I know there are a couple more. There are a couple more questions. We'll have time. Folks will be around. We will, as the day progresses, get more interactive with you all. But we've got a special guest now. Is Ben Kalis here? Where is he? Ben, why don't you come down? We've asked